The U.S. Supreme Court on March 4 issued a very important decision in a Clean Water Act permit case that makes sure that contractors who follow the terms and conditions of their NPDES, or National Pollutant Discharge Elimination System, stormwater permits, are protected from enforcement action. I'm Leah Pilconis. I'm General Counsel for AGC of America, and I oversee our judicial advocacy efforts. AGC submitted a friend of the court amicus brief in this case because it is very important to construction. We, as an industry, on most of our projects, have coverage under a National Pollutant Discharge Elimination System permit. The court was very clear in its ruling that the Clean Water Act does not allow EPA or an authorized state that's issuing one of these permits to put language in the permit that makes the permit holder responsible for the overall quality of the water body that it's discharging into. If EPA or a state issuing one of these permits was allowed to put language in the permit that says, construction site operator, you cannot have a discharge coming off of your job site that causes or contributes to a violation of a water quality standard. Think about what that would mean. That would mean that if a construction site is near a water body that is impaired for sediment, even if a drop of sand or sediment would run off the construction site, and that would lead to a water quality issue, the contractor could potentially be subject to enforcement action. The permit writer, whether it's EPA or the authorized state, it's their responsibility to include in the permit what the permit holder, the contractor, must do or not do to be in compliance with the permit. If they follow the permit, then they are afforded protection under the Clean Water Act. It's called the Clean Water Act Permit Shield. The Construction General Permit lists out very specific best management practices, operational controls, pollution prevention measures. What it does not include is a one-size-fits-all number limit. The Supreme Court was clear in the opinion that the current structure and framework of the Construction General Permit is allowed. And in fact, in making that point, the court cited AGC's amicus brief. And this is important because we have fought for decades to keep a one-size-fits-all number limit out of the construction stormwater permit. It's not practical because of varying climates, different site conditions, different topography. Currently, AGC is very active in the courts. We have over 20 pending judicial actions. It's common for us to submit friend of the court briefs to represent the construction industry's interests and to make sure that the construction interests are heard and understood.